Hey again, everyone. It's Rob Ryder, and it's Sunday, March 13th, 2022. And we're going to talk about this thing called a pure bill of discovery and equity because it discovers things like unknown defendants and more. And apparently, it really is the first step in a civil action. Although, I've never heard that said, but until I read it here specifically because I was looking into pure bill of discovery, that it even existed. And, so because of that, uh, I filed it into some guy's court case, and Jeff in Florida, and it got an answer from an unknown defendant to file an answer into the court case. And so when we're all done, that's what we'll be looking at. But we need to discuss a little bit about what the hell a pure bill of discovery is first. All right, so let's do that. And I'm Staff Sergeant Robert Allen Rutluski, U.S. Army veteran. Never gotten a discharge order, nor has any other veteran. So don't give up your rank. Don't let them call you a mister. Right? You do not want to be a mister in the jurisdiction of an esquire because you're a much lower class than an esquire, which is not a title of nobility. That would be a knight, but they work for a knight. Right? They're a crown agent. By definition, what's an esquire? They're a crown agent. It says so in the dictionary. It's the common definition of what an esquire is. But like I said, I go as Rob Ryder. Makes it a lot easier for everybody. And my email address is courtofrecord@aol.com. Now, I'm not claiming to be an expert at pure bill of discovery, and I don't want to help you do yours, and I don't want to discuss a lot of theories about it. I'm just talking about what I did with one and what we'll find out, maybe next week as this stuff just keeps rolling along. So just because I do videos and this stuff doesn't mean I want to, try to do it for everybody. I have no interest in that. I'm just sharing it so you can see what the law says, and you can go try it and see what happens. Right? If something happens, well, let me know. Well, then I'm interested. Right? But it's not hard to do. It's just a matter of doing it. So, anyways, let's talk about a pure bill of discovery. So, what is it? A pure bill of discovery lies to obtain the disclosure of facts within the defendant's knowledge or deeds or writings or other things in his custody in aid of the prosecution or defense of an action pending or about to be commenced in some other court. In other words, it's how you get evidence. Right? Proof and evidence is gotten by a pure bill of discovery. Deeds and writings, well, that's evidence. Right? Facts within the defendant's knowledge, that's testimony. Right? The difference is this is testimony that you're going to use immediately to prosecute your case. You're just not trying. There's another kind of discovery where you just want to, what's the word? You want to maintain somebody's testimony for later. Right? Well, that isn't what this is. We're not saving it for later. We need it now so we can prosecute the case we want to prosecute. That's what this pure bill of discovery is for. Florida courts treat bills of discovery as the first step in a civil action and allow such to be amended to state a cause of action at law. Right? Because equity and law are separate. You go in equity, you get the information, you come back out, you amend your complaint now to have a cause of action at law based on the evidence that you can now bring to court because you got it through equity. It's a wonderful system. Right? Florida Rule of Civil Procedure, there shall be one form of action known as a civil action. Right? And then going on, noting that Florida courts consider bills of discovery civil actions. Well, there you go. So that's if you're the plaintiff filing a complaint, right? You're going to file a complaint for a pure bill of discovery to get information that you need for your action. But if you are the defendant, like in a foreclosure, you can still do it to get information you need from the plaintiff to defend yourself. And so that's really what we're going to look at today is that, using it on the defensive side more than on the prosecutorial side. But you can use it to prosecute. And technically, according to this, it's the first step is to file a, bill of discovery. So, and they call it a pure bill of discovery, as we'll see. So that's what, we're going to talk about. And I'll show you a few things that I read. I suggest you go read some more on your own and find out something works. Let me know what happened. Right. So I guess let's just start at the beginning. This is how this started. I was actually looking in Michigan at some laws for something I wanted to do, and I came across this thing called Bill of Discovery. Right. It was in the Michigan compiled laws, 600.2924, Bill of Discovery. An equitable action seeking relief in the nature of bill of discovery may be filed, and the defendant shall be compelled to answer, blah, 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 blah. And then went on to say about because you're charged with having given to another person a power of attorney to enter upon a judgment or having confessed or suffered any judgment purporting to be for sum or debt, yada, yada, yada. I said, well, that really sounds like what is happening in a foreclosure, right? Where they say that you have this mortgage and there's this note and that's their evidence. And because of that, you have to pay on this money. They never show you that there was ever a contract between the lender and the borrower, right? Because you have to have a bilateral contract for anybody to lend you anything. So if that didn't happen, well, then the mortgage and the note may have been things that were going to be used, but the contract never happened. So, there were just documents in the contract that never got executed because the contract didn't get executed. But that's not how they're portrayed. They're being portrayed like this is you giving us power of attorney to do this. Right? It's like your unilateral contract, which is a gift or a donation, but it can't be used for business. Right? And this is all supposed to be based on some business contract that you had with the bank at some time. So, there's information you don't have. You need it from them. And I said, well, I should be able to get it by bill of discovery. So then I started, let's Google bill of discovery and see what comes up. And I found this, right? A complaint for a pure bill of discovery, a living, breathing, modern day dinosaur in the Florida Bar Journal. I said, well, that's cool. Hey, I'm helping Jeff in a foreclosure case and, maybe we can use this in this case, so I'll go ahead and read a little bit. Where it said, this article examines the ancient, equitable remedy known as pure bill of discovery. A pure bill of discovery is initiated by filing a complaint which seeks relief in the form of discovery. Right? That's all it wants, just wants discovery. It is usually brought to obtain disclosure of facts within the defendant's knowledge, or of deeds or writings or other things in the defendant's custody, or in the aid of prosecution or defense of an action in some other court. A pure bill of discovery is distinguished from other types of bills of discovery in that the only relief sought is discovery and nothing else. Filings of complaints for pure bill of discovery have been limited since the adoption of modern rules of procedure. Most discovery requirements in cases can be met by using the standard methods available in the rules. Nevertheless, a complaint for pure bill of discovery can satisfy certain needs that cannot be met under the rules. That's just wonderful. So we're no longer following the court's rules that tell you how you need to do a motion and everything else. You're just filing a complaint into the equity side of the court, which is supposed to be the church side. I mean, if we went back and looked at the common law of England, where our system came from, they had a court of equity was the court of chancery and the court of exchequer. Those were courts of equity, royal courts of equity. And then the courts of law were the King's Bench and the court of common pleas. And a court of law can only give you damages. It can't change a contract. It can't do anything other than give you damages. And it's going to, in a court of law, depends on what the record is. So if the record says something contrary to what you want it to say because there's an omission of facts or something, which is what they do all the time. There's errors and omissions in all the records that are filed by esquires. And they, damage your interest because, like on a warranty deed for your house, they don't really have your name on it, right? They make up a legal fiction using parts of your name and call it the grantee, but it doesn't use your full legal name. And if it's you and your wife, it doesn't use both your full legal names. They make up some bullshit using parts of her name, parts of your name, husband and wife, and then they call it the grantee. Well, that whole thing is the grantee. So it's not you, right? So when you go say you own that house, that's not your name. And this is what years ago I talked about, well, that's why you need to go down and claim it as a fictitious entity. Say, well, that's what I was doing business under. But unfortunately, here we are, right? Still trying to get the shit figured out. So anyways, this is what it said. It's a little article here that give you some background on it. And so if you wanted to use this, you should go do your own research on pure bill of discovery. That's what we're talking about. Pure bill of discovery in equity. And then another thing that I had found at the same time was, because of the way they talk about it in Florida, this is a Southern District of Florida, United States District Court, case number 06-80700-CIV. You don't need all that. If you Googled this case number and you're looking for document 25, which is this order denying plaintiff's motion to remand. Sorry about that. Hang on a second. Okay, so which has all sorts of things about bill of discovery in it, right? Plaintiff filed this action as a complaint for pure bill of discovery in the Circuit Court of the 15th Judicial Circuit in and for Palm Beach County, Florida, on June 20, 2006. So in this case, it was a plaintiff using a complaint for pure bill of discovery to get information about a defendant. Right? That's what the case is about. But then it goes on to tell you about pure bills of discovery. A pure bill of discovery lies to obtain the disclosure of facts within the defendant's knowledge or deeds or writings or other things in his custody in aid of the prosecution or defense of an action pending or about to be commenced in some other court. Right? And a court of law and a court of equity aren't the same court. So, when you go to equity to get this, when you bring it back to the court in law where the case is already going, they're two different courts. Matters concerning what it can be, noting that a bill of discovery may be used to identify potential defendants and theories of liability and to obtain information necessary for meeting a condition precedent to filing the suit. Florida courts treat bills of discovery as the first step in a civil action. There's no more to be said, right? Don't let any attorney tell you different. According to a United States District Court, in Florida, Florida courts treat bills of discovery as the first step in a civil action and allow such to be amended to state a cause of action at law. There should be one form of action known as a civil action. Noting that Florida courts consider bills of discovery civil actions and permitting removal of a bill of discovery, in part because it can be amended to add substantive causes of action. Right? Because remember, the first relief you're looking for is just discovery, right? But once you get the discovery, then you can amend your complaint to, go after whatever it is you were intending to go after you got the evidence that you needed to prove your claim. And that's what we're going to do. So, enough on that, right? I'm not trying to make anybody an expert in bill of discovery. I barely know it myself. But I don't need to know how to use it. I just go put it in and see what they do with it after you put it in. So let's talk about that stuff for a minute. Hang on. Okay, so let's really just begin at the beginning. This is the case we're talking about that's in Orange County, Florida. In a second, I'll show you where to go look for it. Right, and this is the complaint in a foreclosure. Right, the plaintiff. This is supposed to be the lender or the borrower, or I guess they call themselves the borrower. And then here's all the defendants, and unknown tenant, whose name is fictitious to account for parties in possession. Well, who the hell is that? It doesn't say, but there are unknown defendants in this court case. And we'll see if that changes when we get to the end. And then it does, then da-da-da-da. So this was the reason we were in court. And one of the things is, you look at number 2, the borrower, Jeffrey Charles, executed and delivered a promissory note, right? Executed a mortgage. The mortgage was recorded in the official records, this ID in the public records of Orange County, Florida. And the property described in the mortgage, copies of the note, mortgage are attached here too. Okay, so let's just stop there for a second, because this claim is relying on this mortgage that is the official record document under this ID number. Well, if you go to the public records of Orange County and get this ID number record of the mortgage, that it's a copy of what you signed as the borrower, you'll see that they've added things to it that weren't on it when you signed it. Right? Well, that would be good to know. So this information is in the official records, and whether you're in a foreclosure or not, you should go get a copy of this official record and follow along, and you'll see why you'd want to know this stuff in the future. But it isn't in the court case, right? The official record is like in the county clerk's office, or I think here in Florida they use the comptroller's office or something like that. But, I'm just showing you this is what they're relying on, right? That this has happened, and then there's an official record, and here's our proof. Well, we should go see what it is they have that they're claiming to use. But then they went on to say that the note at issue in this action is endorsed in blank. Now, if you've not watched these videos before, they take your note after you get done, they put a stamp on it, and they endorse it in blank. It doesn't have, there's a place on there for pay to the order of, and it's left blank. That's a blank endorsement. But they take your private note and they turn it into a fucking check, because they make it paid to the order of. Right? And so, they've negotiated your private note into a private public note. And it could be paid in legal tender if somebody was to sign or put their name on the pay to the order of line. Right? Write your name in and take it in the bank. So I want to cash this check, because it's a check. It says pay the order of. That's a particular form of words that are used on checks, money orders, and drafts. I think are the three things that say pay to the order of. Right? There are other ones that say like pay to or something like that. Okay, so anyways, this is important to know, right? That this is what they're basing their thing on. Okay, hang on just a second. Yeah, okay, there it is. And then if we go look at what that was, because it was attached, they said, here's the attachments. And we'll see that there's all these little blank boxes on there, right? Like all this shit has been, scrubbed. So, I look at it the first time, I said, well, if they're doing that, then the information isn't there anyway. So nobody signed these documents. Everything is blanked, right? And if you're saying this is what you're relying on is this document, then this one they just simulate a note. Right? But here's that endorsement, right? Pay the order of. It's blank. So this was supposed to be Jeff's note, although the first page of the note, for some reason, is the last page of this filing, 25-page filing. But this is his note. And the last page of the note is an endorsement, a blank endorsement. Well, that wasn't there when he signed it. They put that on there afterwards. Right? But by somebody doing this, they have just made this a check. Because that's the exact same thing your check says when you fill it out. And then we go on, and here's the mortgage, and, it's got a big blank box. And we're going to find out here in a little bit when we look at the real deal that there's a case number hidden underneath here. Well, it's not the case number of the court case he's in, but there's a case number. Well, where was that case at? And that's why I'm saying, look, there's been a foreign judgment filed already. That's what that case number is showing. Right? But everything's blanked out. Right? So this isn't the official record because it's been blanked out. But this is what they filed in the court case. And, I don't know what else to show. There's all these other documents, but every document that was attached to this thing has got the same defect. I'm not really sure what that was. But, well, here's the first page of the note. Yeah, there it is. See, even that stuff. It says case. You can see right case. It says case on right there. Okay, somebody has already opened a court case somewhere. Now, the interesting thing about Florida is both a state and a tribe. And I need to go find one of them official pieces of. It's on an official form of Florida. Let me see if I can find it. Hang on a second. Oh, I'm not going to be able to find it. It was in my brother-in-law's stuff someplace, but it was a form he had to fill out for something he was doing, and it says on there, Florida has state/tribe. Right? So, there's two jurisdictions called Florida, and they have the same thing in Michigan where it's actually written in the Michigan law that if one of the Indian tribes' tribunals has a judgment, right, it can be filed as a foreign judgment with the Michigan court and vice versa. So, they have one of these cooperating agreements to enforce each other's foreign judgments. So you can see where it'd be really easy to have a judgment someplace you don't even know about, filed somehow by somebody who's acting like you as like under power of attorney, because you signed some piece of paper and they say they gave them power of attorney, so now they're signing for you and they agree that you are guilty of this charge or whatever, and now there's a foreign judgment against you. Then they take the foreign judgment and they bring that to the state court, and now they're just trying to get their foreign judgment enforced. But the foreign judgment is a judgment, so by the record, you're already guilty. And the other way to get out of that shit then is to go to the court of equity and say, well, I need to see what these people have against me so that I know what I need to fight. Because, according to this, it's being hid. Although when you go look at the original record, as we will, there is a number there. So let's continue on. Hang on a second. All right, before I close this window here, right? The complaint for pure bill of discovery. You should Google this, Florida Bar Journal, complaint for pure bill of discovery. I'm sure you can find this article if you're interested in. It would tell you lots about the things we're talking about. And then for what we're talking about, if you were to Google Orange County, Florida court records, right, and go under this hit here for the clerk of courts, you will find you can put a case number in, right, not a robot and search, and you could be looking at this case we're going to be looking at. That's how simple it is. This is, the nice thing about Orange County is they show you all the records. Well, by and large, all the records that have been filed into a court case. Okay, so this is what we filed. So in this case, right, then there's a docket. And if we went back and we looked at right here, we filed it as a notice, pure bill of discovery and equity. Right, that's the proper name, right? Pure bill of discovery and equity. And it looked like this. And right, complainant Jeffrey Charles files this equitable action seeking relief in the nature of a bill of discovery because of a civil action by which it is charged I have given to another person a power of attorney to enter a judgment purporting to be for sum of a debt due when in fact nothing or any other part of that sum mentioned in such power of attorney or judgment is due. I know that's really difficult to say or to understand, and I'm not going to try to go through it again, but I'm just going to show you where it came from. And you can go download your own copy. Hang on just a second. Right, Google MCL, Michigan Compiled Law, so MCL 600.2924. Right, I just took this, basically the phraseology out of this, and put it into Jeff's pure bill of discovery and went on from there. And, one day it ended up here, and wherever here is. Where the hell is that thing? Here it is. Right, so that's where that verbiage came from. And secondly, because the Esquire is acting as the plaintiff, are using an insufficient process that omits service and are not signing any of the filings made on behalf of the plaintiff in accordance with the court rules, the complainant, Jeffrey Childs, has no idea who his accuser is or what he's being accused of. And so this is something I pointed out prior, right, that if you look at the paperwork that's in the court case that you're the defendant of and you start looking at what's being filed, there's no attorney signing the paperwork. There's somebody putting a chicken scratch, but the rules say that an individual attorney has to sign. And in the case of, in Jeff's case here, it's almost always like a byline where they put some other attorney's name in their office, and then it says by, and then somebody else signs, and then it has their information on. Well, it wasn't signed by the attorney in his individual name. It was somebody signing a freaking byline. So it was not signed by the court rules. Okay, and then finally, the plaintiff's representatives are impersonating as officers of the state of Florida unless they can provide or prove by record or certificate that they have complied with federal law 4 U.S.C. 101, 4 U.S.C. 102, and recorded the oath of office mandated by the Congress of the United States for the several states' officers. Without such record or certificate, these individuals are violating the 6th Article of the Constitution of the United States. It's really that simple, right? I showed it many times. 4 U.S.C. 101, Google it. 4 U.S.C. 102, same thing. 101 has the oath, and 102 says what has to be done to make a record of it. The point is, it's the oath taker's duty to do this, not anybody else's duty. They have to have proof that they did it, a record or a certificate, and if they don't, then they didn't do it, and so they're not a state judge, or they're not an attorney, or they're not a school board member, or they're not any other office that requires you to take an oath of office. Because if your job requires you to take an oath of office to your state, you have to first take an oath of office to the United States. It's in the Constitution. Article 6. Right? Okay, so in conclusion, only by pure bill of discovery can the evidence required by the defendant be obtained to prove the identity of the individuals impersonating state officers and simulating legal process under cover of law. These belligerents have made me the victim of their unconstitutional acts, crimes, and conspiracies against the United States that adversely affect my life, liberty, and property rights, titles, and interests without due process of law. I need this information to prosecute their crime in law. I don't need it for later. I want to use it now. That was the idea, right? So that's what we put in, right? So I don't need to write this for you, right? You can just read what it says. It's 4 short paragraphs. I like to get shit to fit on one piece of paper. And that's what Jeff filed, right here on the 28th. Now, in Orange County, he has access to electronic filing, so he can do all this stuff electronically. But not everybody has that luxury. And I don't really think that it should be filed as a notice. If there was a way to file it as a bill, I'd say file it as a bill, because that's what it is. It's a pure bill of discovery. But if there's something for discovery, well, then file it under discovery. Call it pure bill of discovery. But it's probably not technically a notice. That's what I'm trying to say. Now, putting it in and making the court take notice, they can, of course, they don't need to have a freaking motion done by the rules. They can say, hey, man, that's what the thing says to do. We're going to do it. Right? They can take cognizance on their own. Because something happened Because as we're going to see, eventually we end up getting a hearing based on this pure bill of discovery and equity. I just want you to pay attention to the date. So this is the end of January. Where are we now? We're in the middle of March, right? So it didn't happen immediately. And then all these other things happened. I had a hearing on something, had some court minutes on. Oh, about this, it had to do with the plaintiff wanting to file an amended complaint. Okay, so that was all that. And then we put in a I'll put in a request, right, for judicial notice, right? Because a request is, again, that's something done in a court of chancery. And asking, well, I might as well look at it. It's on one page, right? Taking judicial notice. Oh, shit. Yeah, a second. Yeah, then a couple weeks later, we put in a request for judicial notice, violation of Florida rules of judicial administration, You know, again, this is something that is just based on what the rules say you can do, and they're not signing their paperwork. That was a big deal. You know, these people are not signing their paperwork in their full legal name. I don't have time to read all these, or we'd be here forever. So, but you know, all these things are happening, And then all of a sudden, somewhere up here, we get this thing about a notice of hearing. Right, where now this is the 24th, so almost a month later, right? We put it in on the 28th of January, 24th of February. Take notice, right, that there's going to be a hearing on a pure bill of discovery and equity. Filed 128, so, you know, but the thing is, it's the plaintiff's attorney that's filing the notice and the certificate of service and who they filed it on. It's like, well, Jeff didn't have to do it. They did it. Right? Jeff put in a notice, said for pure bill of discovery in equity, and all of a sudden we're getting a notice that there's going to be a hearing on March 7th, which was, you know, last week. Right? My point is, he didn't put it in, they put it in. Well, then there's another one right afterwards, and this is the one that he put in. Right? Jeffrey Charles put it in. So you got all these things happening, right? So kind of confusing, but at the end of the day, they had a hearing. And after the hearing, some court minutes were produced, and the court minutes say that there was this hearing where there's the plaintiff, right? Loan Depot LLC, plaintiff petitioner, versus Jeffrey Charles and all these other people. But now all of a sudden, notice that the clerk of the court and state of Florida are listed as defendants. They weren't on there before, and now they are. And then it goes on to say that Jeffrey Charles, the defendant, and this other person, this Vanessa Dawn Sloat Rogers, is the attorney, the Esquire. All right, it says right there, Esquire, Crown Agent. And it was ruled that the plaintiff's pure bill of discovery and equity is hereby legally insufficient. Defendant's counsel is to prepare and submit order to the court. And you say, well, hang on. The plaintiff isn't the one who had a pure bill of discovery. It was the defendant. You know, it was Jeff's pure bill of discovery. But they're saying, no, it was the plaintiff's, and it was legally insufficient. And now the defendant's counsel to prepare and submit order to the court. Well, Jeff doesn't have any counsel. He's been doing this whole time. But as it turns out, well, hey, there's a whole bunch of people that were listed before. Like the state of Florida, well, they would have their own counsel. And as it turns out, so does the clerk of court, Orange County, Florida. She has a general counsel. And the general counsel filed an answer after we had done this, right? This is all happening on the 7th. Well, then I got busy. I had so much going on. I said, Jeff, it's going to take me a while to look at this stuff because I had so many things going on. But he went ahead and he kept filing paperwork. I'm just trying to find out where we're at. Oh, here we are. Okay. So he got out of the hearing. He didn't think that went well for him because of what it said. And so he was filing all these motions for dismissal, discovery, going on and on. That's what all this stuff is for. Until we get to the last entry of the day on the 10th, right? So 3 days after the hearing, well, there was an answer put in. Well, now we're going to look at the answer. So hang on a second. Okay, so here is the here's an answer. Answer of defendant, clerk of the circuit court, Orange County, Florida, in claim for surplus funds. And you'll notice here, right, there's the clerk of Orange County, Florida, and the state of Florida Department of Revenue listed as defendants, but they weren't listed on the original complaint. Right? Unknown tenant. It said nothing about the state or the county, right? The clerk's office, and all of a sudden they are. So apparently putting in the pure bill of discovery and equity did something. And so let's go back and look at what the order said again before we read this. Right? The court said plaintiff's pure bill of discovery and equity is hereby legally insufficient. Defendants counsel to prepare and submit order to the court. Right? So, answer of the defendant. Now comes clerk of the circuit court, Orange County, Florida. Clerk, by and through her undersigned counsel, and files her answer to the complaint stating as follows. Right? So the clerk is now answering as a defendant a case that had been filed 2 years ago. Well, was the clerk always a defendant and we just didn't know it? Because if she was supposed to file her answer 2 years ago, right? 20 days after being served, you're supposed to file an answer. They're just filing it now. Just pointing that out. But the clerk admits the allegations in paragraph 2. We'll go back and look at that for purposes of jurisdiction and venue only. And then regarding paragraph 18 of plaintiff's complaint, the clerk admits only that she has and asserts an interest in the referenced property by reason of the referenced and recorded judgment. The clerk is without knowledge as to the remainder of the allegations contained in the plaintiff's complaint. Wherefore, in view of the above, the clerk prays this honorable court for the following relief: to establish the priority of all liens against the referenced property, and to provide for the protection and payment of liens if at the time of sale pursuant to the final judgment of foreclosure, the purchase price bid and paid exceeds the amount owed to the plaintiff, and to disperse to the clerk the proceeds to which it is entitled to by virtue of its interest in the subject property, and to award any other relief deemed just and proper. Well, this third one then could apply to any of the other defendants. I mean, this is like an open-ended prayer from Roberta Walton Johnson, who's the general counsel to the clerk of the circuit court, Orange County, Florida. Right? So this is a government attorney. Right? This is no longer a private matter. This just became public because the circuit court clerk has, been made a party to a case. And then if you look who got served, right? They're all esquires. Esquire, Esquire, Esquire. And I think that right there, Roz Flaw, right? That is the attorney of record, right? But don't know who these people are. They've never shown up before, whatever the name of this company is, right? But they're being served now. by the general counsel to the clerk of the circuit court. Now, Jeff didn't get served, which is interesting, right? These people got served. But it's, it's like the general counsel did what the judge said to do. Defense counsel to prepare and submit order to the court. So that's what that's what she did. She submitted an order to the court saying, well, court, why don't you go ahead and establish a priority of all liens against the referenced property, provide protection and payment of the liens if at the time of sale pursuant to the final judgment of foreclosure, the purchase price bid and paid exceeds the amount owed to the plaintiff, and to disperse to the clerk the proceeds to which it is entitled by virtue of interest in the subject property, and to award any other relief deemed just and proper. Well, that could be, well, then give Jeff his relief also. So, that was just put on the 10th, and we'll see what's going to happen. But the fact that they did it is, all of a sudden out of nowhere, the clerk of the circuit court has become a defendant in the court case. And so has the state of Florida Department of Revenue. Okay, well, where's their answer? We could go down that road. Well, let's take a look at what these things were, right? What were the things in 2 and in 18? So in 2, it was, it's, based on this information here that the mortgage is recorded under this item number right here, okay? We haven't looked at the official document yet. We're going to get to that in a second, but that's what the clerk is based on. The clerk is answering for 2 things. Number 2, that because of this, it has to do with the venue and jurisdiction and venue only, right? And then regarding paragraph 18, let's go look at 18. Okay, pursuant to the Fair Debt Collection Practices Act, you are advised that this law firm is deemed to be a debt collector attempting to collect a debt, and any information that obtained will be used for that purpose. Well, that's really interesting because, the law firm involved is the plaintiff's attorney. And they're a debt collector because the plaintiff, by name, is not a law firm. They're the bank. They're supposed to be the lender. Right? That's what this LoanDepot.com is, LLC. They're listed as the lender on the mortgage and on the note. So they're not the law firm. Well, then who does that leave? Right? It really only leaves the plaintiff's attorney to be the one they're talking about. Right? These people here. Which, an interesting thing about this, right? They were the original plaintiff. If you look at this number named Diamond, you're going to see that's the same name of the guy who has the official records. But they were the original plaintiff's attorney. And then because of the shit we did, they've gone away now and they got replaced by, like a bigger firm. The same thing they did with the Warren in New York. We put paperwork in his. It was the constitutional question, and next thing we know, the original plaintiff's attorney is gone, and they've been replaced by this attorney firm that's from downtown Wall Street. But so anyways, what they're saying is, this is Phelan, Hallam, Diamond and Jones, PLLC, was acting as a debt collector. Right? Pursuant to the Fair Debt Collection Practices Act, you're advised that the law firm is deemed to be a debt collector. Okay, well, that's fine. Well, if they're a debt collector under the Fair Debt Collection Practices Act, which is a federal law, then they're a debt collector under the state's law or statute about debt collectors. And if we go and read that, which we will here right now, we'll see that Well, they can't do that. You can't claim to be a debt collector and then claim to be somebody's attorney. Right? So they're violating the law. Hang on a second. Right? Florida statutes 559.72. Prohibited practices generally in collecting consumer debts. No person shall. And it gives a list of them. And a little bit easier for me to read this on something like this. So, and if you go down here and you start looking at 9, 10, 11, 12, right? I'm saying they could have violated all these, but they certainly violated 11 and 12, which is 11, communicate with a debtor under the guise of an attorney by using the stationery of an attorney or forms or instruments that only attorneys are authorized to prepare. Right? A debt collector cannot do that. It doesn't matter that they're an attorney firm. They said they're a debt collector in this case. So they can't act as an attorney and, like do it like they're doing it like an attorney. Orally communicate with debtor in a manner that gives a false impression or appearance that such person is or is associated with an attorney. What else we got? Claim, attempt, threaten, or to enforce a debt when such person knows that the debt is not legitimate or asserts the existence of some other legal right when such person knows that the right does not exist. And use a communication that simulates in any manner legal or judicial process. That's what we're in now. Or gives the appearance of being authorized, issued, approved by government agency, or attorney at law when it is not. Right? So if they're a debt collector, attorney, and they're taking you to court as the attorney of record for a plaintiff, I say they're violating the Debt Collection Practices Act. Oops, sorry. So anyways, this is kind of a separate issue, but this is, an ongoing thing that's happening as part of this process. That they admitted in their complaint that they're a debt collector. The law firm did. And if a law firm's a debt collector, then the law firm can't be the attorney for a plaintiff in a court case for the same debt. They said they were the debt collector, not an attorney for a debt collector. All right, but that was this section here, number 18. So if you're in a foreclosure in Florida, you probably have the same thing in your record. Right, and like 17, all the above mentioned recordings, official records, books were in official records of Orange County, Florida. Well, now we're going to look at that. Let's see what they actually put into the record. So hang on a second. Right, hey, Phil Diamond, there's that name. Phil Diamond, comptroller. Search official records, right? And Diamond's one of the names in the original plaintiff's attorney's names. Click here to search. Let's see where we're at. Disclaimer. Yeah, I accept. Sure, whatever. All right, you can put the information in. So if you put in the numbers that were listed in the complaint of the official records, right, you end up looking at the official records, which look like this. All right, this is what the official record looks like. There ain't no dark spots. There's nothing that's been blanked out. And right on here on the mortgage, right, this is the mortgage that Jeff signed originally. It's got the loan number, the MIN number, the Mears phone number, the PIN number, and a case number. Well, where the hell is this case at? Right? None of this was on there when you signed the documents. And yet there it is. Right, and then every page you go through, these areas are blanked out before. This stuff down here is blanked out. This, this is a barcode, goes to something. This has been certified, registered, whatever, somewhere. Well, that's all been blanked out on the copy they put in your court case. So, there is Jeff has been made the party to a case somewhere. Let's see, load. And if you notice, it doesn't say they filed the note. Right? They said they filed the mortgage. That's what it says in the complaint, that the mortgage had been filed in... the mortgage was recorded in the official records, but the note wasn't. Right? Copies of note and mortgage are attached here too. So... only the mortgage was filed, along with these different riders that go on it. But at the very beginning, right in this 19-page official record, starts with the fact that there's a case someplace going on. So somebody over here, the recording people, have to know where this is at. So, it's one of the things we're going to find out. But the other thing was that because there's a good chance, so, what the point is, what are you going to do now? They've already put the answer in, right? So that may do its own thing anyways, the answer that the general counsel put in. But what I'm going to do with Jeff is we're going to write the general counsel and point out the fact that, the attorney of record, the one who claims to be a debt collector, is violating these sections of the Debt Collection Act. I'm going to go look at the Federal Act too, find something they're violating in there, and take him to the attorney of record, or excuse me, the general counsel for the clerk's office. Right? Because if they violated the Florida statute or the federal statute, well, then that violation affects all the defendants, not just Jeff. It affects the clerk also. The difference is the clerk's got an attorney. Right? General counsel, this is not a private matter anymore. It became public matter. Somebody violated a public law that's affecting the state, the county, or the courts, right? Clerk of the circuit court, and Jeff. And so Roberta Walton Johnson should be able to get everybody relief. And maybe that's what she did by, writing this very simple order. Wherefore, in view of the above, clerk prays the honorable court for the following relief. Right? To establish a priority of all liens against the referenced property and to provide for the protection and payment of liens if at the time of sale pursuant to final judgment of foreclosure, the purchase price bid and paid exceeds the amount owed to the plaintiff. To disperse to the clerk the proceeds to which is entitled by virtue of the interest of the subject property and to award any other relief deemed just and proper. That could all be for Jeff. In these foreclosures, they're really going after the money. Because the money and the property are not, in the land, are not tied together whatsoever. Nobody ever lent you any money for the land. But you've been putting all this money, you signed a note that's been converted to a check, so it's now worth whatever the note said it was worth. And you've been making payments all this time that have been going into an escrow account because there never was an agreement with anybody to loan you any money, so you're not paying off a loan. The payments are going like good faith payments into an escrow account. Right? Well, all that is yours because apparently the lender doesn't want to do business with you. They didn't sign the agreement. And they can't hold you to things that only have your signature on it because, it's a business. It's supposed to be a business arrangement, and so both parties have to sign the contract. So anyways, that's what happened. We put it in, and it got somebody to come out of the woodwork that was not listed from the beginning as a defendant, and now we got not just the clerk of court of Orange County, Florida, but the state of Florida Department of Revenue. They're also a defendant. So we'll see what happens next, right? But that's what's going on. Okay, I don't have much more to say. Like I said, I'm not an expert at any of this. It's just something we tried, and I'm showing what happened. And, over the next week, I'll learn more. And when I know more, I'll come back and tell you more. So please be patient and have a good day. Take care.